question is that the motion be agreed to. Jackie Dean.
Thank you, Mr Speaker. National does not support this bill. The member has given a pretty full account of his rationale for promoting the bill. The information I was given was that the member had intended withdrawing the bill when it was in the select committee stage, so why he has chosen to continue with it, I don't know. But as the member was talking, it occurred to me that the recusal provisions actually proved the point that the current provisions are working. And if we go back to, I think it was around 2004, I'm not quite sure of the time, but it was around that time where there was the Court of Appeal case, and Justice Bill Wilson had failed to recuse himself from that case, and it was the Wallboard Disestablishment Company, some members will remember that company limited versus Saxmere. And it was found that Justice Wilson had a business relationship with one of the counsel, should have recused himself because he had clearly a conflict but didn't. And so in terms of the law, and the member probably thinks I'm agreeing with him, but I think the fact that he didn't recuse himself was determined by the justice that yes, in fact, he should have. He then went on to resign his position, and I think the accountability is there in the existing legislation. And so maybe the issue here is not so much around a register of pecuniary interests, but the provisions around recusal and whether or not that is effective, and I would contend that it is. So I will just move on to the Law Commission report of 2011, where the Law Commission released an issues paper which indeed examined the issue of the potential of a register of pecuniary interests for judges. So in that report, the current law was set out as it relates to New Zealand, England and Wales, described key features of financial registers in the United States of America, India and South Africa. And the Law Commission determined and recommended in its report that a register of judges' pecuniary interests should not be established in New Zealand, and the member did not address that point in his speech. But, Mr Speaker, we do have a committee stage to come, so I would expect and hope that the sponsoring member would address the recommendation from the Law Commission, which said that a register of pecuniary interest should not be established in New Zealand. I mean, the member may care to disagree with the Law Commission over this point, but I think the House would be interested to hear the reasons why. There are also concerns, and I absolutely understand those concerns, that a public register of assets and of financial information could, and I would say would, compromise judges' privacy and, in some cases, safety, and expose them to pressures which they otherwise don't have. And if I think of a district court judge who does a circuit around provincial New Zealand, they are small towns. The nature of the small towns, let's talk about Whanganui, for example. The district court judge comes and does a circuit and appears in the town, I don't know, weekly, fortnightly, whatever the round is. It sits in the court. The same defendants tend to come up against the district court time after time after time. They are known to that judge. They develop a history. They are known clearly to the local police. So it's a pretty small environment and it's a pretty small pond. Now, imagine some character gets his hands on the register of pecuniary interests of that district court judge which is doing the circuit and reads that the district court judge has a residence here, has a residence here, has a residence here, holds a mortgage with some bank and other items, and we're very familiar with those, as members of Parliament. But that information in the hands of an offender who was clearly holding a grudge against a judge has the potential to place that judge under some unwelcome pressure. And I'm not talking about an offender in the dock being less than respectful. There are remedies for that. But I do worry, and I genuinely worry, that judges tend to be quite isolated folk anyway because of the very nature of their job, and I would not like to think that they were needlessly placed under threat by some members of society who did not bear them the best of good wishes. It is believed that the current ethical codes and the common law around recusal are satisfactory in New Zealand. Our codes and our law are substantially the same as Australia, England, Wales and Canada. So far from, as the member sponsoring the bill would have us believe, New Zealand is an outlier. That is not true. And it is believed that we are very much in line with some pretty solid practice. I want to talk about the separation of the judiciary from government, and it was an issue which came very much into our attention in the Law and Order Committee in the previous Parliament when we were considering the Bail Amendment Bill, and that was a bill where members of the public or families of members of the public had an experience with the judiciary. And it was around the circumstances of bail being granted to offenders who then went on to offend grievously in some cases against young people, family members, etc. Those family members who were badly hurt and grieving and will be for the rest of their lives were turning around looking for someone to blame. Of course they were. The decision maker in that instance of who was to grant bail was the judge. Those families laid often blame for the decision to grant bail, and I am keeping it within scope of this present bill, I hope.
Well, I hope you're going to get back this.
I am. Oh, I surely am. No, it's good. Because those families, that member wasn't on the committee at the time, and perhaps if she had been, she might have been as affected by the circumstances as we were. The point, Farfoy was, Christopher Farfoy was, so I'm rather hoping that he will pick up the theme. The point I am making is that there needs to be a separation of the judiciary so that they can make some sound decisions. That is the point. Is that we need our judiciary to remain absolutely separate so that the decision-making they make is the best they can do. Just turning to the select committee process, there were a number of submissions to this bill, very few of whom supported the bill itself for the reasons that I have canvassed in the speech. So it is not a bill which, while I'm sure is absolutely well-meaning, I do not think that it achieves the purpose that it was intended to achieve, because there are other provisions which provide protection for the public against the perception of bias in judges. I also think we need to protect the judges because they need to be free, as I was alluding to in our discussion on the Bail Amendment Bill. They need to be free to make good, independent determinations. Clearly, those determinations are not going to be popular, but it's not a game about being popular. Thank you, Mr. Speaker.